Jerry's trying to get in.
We scoot down a little bit so it is
Yeah.
somehow.
Yeah, the internet.
You wanna slide down or? Hey, Hank, you're on. Jerry. Clock right.
I have 6:55. It's about 3 minutes slow.
6:58. I have 55 as well.
Do you have a set?
What?
Do you have a set in there?
300 minutes, that would probably, I'm not sure what's next.
Okay.
See what we want.
Okay. Just leave it.
Silence settling over the room now.
Fresh air.
I had a good conversation with my nephew. Jeez. I said to Gene, I said, you know, Chris is a little out of his depth now.
That's pretty far over.
He's nice to see me. We can't talk. We can't
Oh,
talk.
yeah.
Did he?
Oh, yeah, that's Elaine's
The minute
niece.
he opens his mouth, his wife says no.
Yep. Elaine's niece is the same way. I said, no, we don't want to hear it. You're going to cause trouble.
Well, you know, in the final analysis, she sounded a little like Ray Paul because when he gets back to her, he goes, Benghazi, Benghazi, Benghazi.
I know. I'm sorry. If you haven't got anything else to grab onto, go for that. Yes, pretty soon it's going to be emails. No, I like this comment. Well, it wasn't 170, it was only 60.
It was only 60. And they were Americans. Good Chris. Good.
They were just working for the national government.
I was going to suggest we hear the STAMI thing, STAMI,
Excuse me?
the STAMI variance first.
Which one is that?
That's the,
Candy cane lane?
Moon.
No, okay, let's do the candy cane lane second.
Pardon?
That's the same one we're talking about. Candy cane is Malone,
Pardon?
right?
It's the Candy Cane Lane, yeah.
Oh, that's what you want to do first?
Yeah.
If, unless
That's
you guys
the
feel,
one.
have any
That's fine.
preference.
No, whatever. Yeah, Candy Cane Lane is the one down by the,
Yeah.
by the landfill.
Yeah. Chris Hayes.
I was gonna say you live right now,
I don't live
but I mean, you're close enough to hang out with those. How did we do before everybody surrounded smartphones and iPads and all that stuff? We were talking the other day about, I can remember, the secretary taking insurance. Remember that?
Yeah, sure. I had secretaries that took sure.
Yeah, and if first started traveling, it was telexes and it was paper tape that you punched in.
Well, I have 7 o'clock, so I will open the meeting. We have 5 of us here, that's excellent. First order of business will be to review and approve the minutes from February 4th. If each of you have any comments on the minutes?
I wasn't here, so.
I have only one on page 10. It says that Stephen noted the deck apparently exists. It seems unfair not to let them put a deck on a porch that exists. I think that got backwards. I think it's not to put a porch on a deck.
That exist.
Yeah.
Do you know?
You got that? That's in the second paragraph. Okay. That's, I
Everybody agree
didn't
with that
have
change?
anything else.
Everybody agree with that change? Okay. I have one. This is the 4th paragraph from the bottom of the first public hearing, where it says, Huntley noted the beauty is nigh the beholder. The house looks better with the porch, and I believe he actually said it looks better without the porch, or he liked it without the porch. And everybody agree that was what
Yeah,
said?
he was making a point.
Yeah,
so,
okay.
yeah.
So let's change that to say the house looks better without the porch. Other than those 2 changes, any other? Anyone would entertain a motion to approve the minutes?
So moved.
Second. All in favor?
Aye.
Okay, minutes are approved. Next order of business, well, we have continuation of 2 public hearings. I'm going to suggest we hear 10 Kane Lane first, if that's okay with people. That is the Stamey application. We have an amended application that's submitted by Edward Alcalay, I believe. Edward? Ed, nice to see you. Yeah, why don't you make a quick presentation and then we'll ask you questions and
Sure.
see if anybody else has anything to say.
Okay.
You're welcome to come up here or with a chair.
Wherever you want.
Why don't you bring a chair up and be comfortable?
Thank you. Good evening. So basically, I'll just summarize my application. I'm not going to go through the whole thing because that'll just waste time. I'm sure you've had a chance to read it. My client took in what this board said last time as well as what some abutters said, and her original proposal was to basically put a screened-in porch on an existing deck that is within the River Conservation District. Based on hearing some feedback from the board as well as from some abutters, she decided to amend that application, and in essence what she's doing is agreeing to take down the deck and basically eliminate the deck, and is asking for a much smaller screened-in porch to be allowed on the house toward the side of the house as per the plans that we submitted.
It's just if anybody wants to refer to it. Okay.
The one thing I'd like to correct in my amended application is I said the existing deck that's there now was 533 square feet, and the new screened-in porch would be 367 square feet. I've been informed by Stephen Weeder that it's actually the new proposal would go from 533 square feet to 225 square feet, less than half of the square footage.
And I'm waiting for triple confirmation from the draftsman at the moment. He's going to send me that, but we're in the zone.
So with respect to a variance, I'll quickly go through the 5 elements. This new proposal, I would say, is not contrary to public interest because he's agreeing to permanently remove an existing deck that is in the River Conservation District and put up something that is far smaller. The spirit of the ordinance would be observed for the same reasons. It's, again, a smaller intrusion into the River Conservation District. Substantial justice will be done for the same reasons. In addition, he's moved the proposed screened-in porch is in an area that is further away from an abutter, and I don't even think an abutter could actually see the screened-in porch, and if the deck is removed, that would be out of the view of the abutter as well. The value of surrounding properties would not be diminished in any way, I don't think, under the original proposal or this one, but it would decrease the visual impact of the Stamey's house on abutters. I think the real question for this board is whether the literal enforcement of the provisions would result in an unnecessary hardship. And I think this board has discretion to determine whether what is meant by unnecessary hardship in this case. In the past, unnecessary hardship was interpreted much more strictly than it has been more recently by the courts and even by the legislature. In this case, the uniqueness of this situation is by permitting this variance, it would actually be making the home and the building in more compliance with the spirit of the River Conservation District. As I said, I don't want to repeat it too many times, but it would be less than half of the square footage. It would be further away from the abutters. It's a situation that would be a win-win for my client, of course. She wants a small area where she's not going to be attacked by black flies and mosquitoes, so she's doing this for her own benefit. But it would also be a town win because the town would, in effect, be coming more into compliance with the spirit of the ordinance and, in fact, the footage of the ordinance. In addition, this proposed new screened-in porch is actually further away, approximately 5 feet further away from the river than the existing deck. And again, my client would extinguish the use of the existing deck and never put it back. So the town would be winner, and I think the abutters in this case would also be winners because it would be a less intrusive within their field of vision and be smaller. In terms of the unnecessary hardship argument, the last statement I would make is this deck has been grandfathered in, and in agreeing to extinguish that use, and she's asking to receive the benefit of a less intrusive area. The uniqueness of this particular situation that falls into it is not necessarily the land itself, but the use of the land. It's a situation where the uniqueness is in granting the variance, you're actually doing something more of a benefit for everybody, including the spirit of the River Conservation District regulations. That's all I have. That's a summary of what I have.
Any questions from anybody?
I have one question. Do they have a right then to put a patio there because it's not a structure and we have no say on that? Just to clarify things? It doesn't matter.
Well, that's, I think that, I mean, that's a hypothetical question. I think, so I'm not sure
It doesn't matter.
we should be answering it.
Okay. Just asking.
You said you spoke with the abutters. Did they have any comments? What was there?
I did not speak
Oh, I'm
with
sorry.
the
I thought
abutters.
that was-
One of the reasons, I apologize if I don't think I said that, but we specifically moved it away, or my client proposed to move it away so it will be out of the
Okay.
view of the
Okay.
abutters. I didn't speak
I thought
to them,
at some
no.
point
You said your client had input from an abutter.
Okay, yeah.
That's what you said.
Well,
I don't have any proof that she spoke to any abutters, or Stephen spoke, or anybody spoke to abutters. It was done, the input from the abutters, what I was talking about was the last meeting here. I understand from the minutes that there were some abutters here who had concerns. That's the input that she would have put into the no proposal.
I'm still struggling with this. So you're suggesting that the special conditions of this property that distinguish it from others in the area is the, I guess, the willingness of the owner to remove part of a non-conforming use? Is that a fair statement?
It's a fair statement, but it's not just removal of a non-conforming use. It's a removal of a non-conforming use that is substantially greater than what is now being proposed, and I think that is the
Yes.
unique situation that this falls in, yes. And I would add, I'm not granting this variance would be worse for the ordinance than actually granting the variance.
Okay. I don't have anything else. Right? Great. Please take a seat.
Thank you.
Are there other people who have a direct interest who have any, would like to make any statements? Okay. Then I think it's time to discuss and perhaps decide this. I'll
Can you
Go
start
ahead.
down there or over here? It doesn't matter to me.
Start there.
I think that this is a reasonable approach to this. It does decrease the impact on the River Conservation District. It's a case where I think the spirit is perhaps more important than the literal interpretation here. I don't think we need to be bound by, at least from what I've read, court cases and stuff, by an exact word-for-word interpretation. And I think it's an excellent way to solve the problem. That's just.
Anybody else?
Part of the prong of unnecessary hardship is that, other than special conditions, is that no fair and substantial relationship between the general public purposes of the ordinance provision and the specific application of that provision of the property and the proposed use is a reasonable one. It's reasonable in that he is making the property more conforming rather than less conforming. And in that sense, I see it as reasonable. I guess I'm open to the discussion of special condition.
Yeah, I mean, the unnecessary hardship, of course, is a two-part test. Yeah, I'm struggling with the first part, which is, you know, showing that somehow this property is being treated unfairly, given the surrounding properties or given others in the town.
Special condition.
Yes. I think I agree that the exchange of a screened-in porch, which has more volume than for a larger deck, is one that is attractive and it makes sense, I think. My difficulty is the ability to swap one non-conforming use for another non-conforming use doesn't exist in our zoning ordinance, and you know, we can't even get to perhaps considering this as a condition to an approval, because I don't see it passes the unnecessary hardship test, the first prong.
Well,
I think, if I could, I'd be willing to suggest to the planning board that we should have the ability to do something like this. I just don't think, we have or my belief is they haven't, the applicant has not demonstrated that they meet the first prong of that unnecessary hardship test, that there's something owing to the special conditions of the property that distinguish it from others in the area. There's no fair and special relationship between the public purpose of the ordinance and the specific application. Again, I think they're being treated the same as anybody else is. So while I support the idea of the swap, I think certainly meets the spirit of the ordinance. I just don't see how we can get there.
And we know that it doesn't have to be a special condition. It doesn't have to be a condition of the land. It can
Yes.
be a condition of the building. That can also be a special condition.
Yes.
So here you've got a building. I don't know whether their neighbors have a deck that runs out to the river, but you've got a building with a large deck that runs out to the river, and they're proposing a change which will remove that large deck and is Ed Alcalay has pointed out, it makes it less non-conforming. And as Jerry has pointed out, it doesn't, say it again, it doesn't.
Well, there's no fair and substantial relationship between the general purposes of the ordinance and the provision of the specific application.
To apply this.
In other words, it's a reasonable use.
But that's the second
To-
prong, but they have to meet the first prong as well.
Well, the first prong could be said to be that the building itself is a special condition in that it's got a deck that runs out to the river or toward the river, and the whole building is in the River Conservation District.
In
So
other
that-
words, anybody with a non-conforming
So
building.
if we had anyone with a non-conforming building who wanted to make it less non-conforming, well, maybe
Each
it
one,
would.
each
It
one,
would seem to
each
me
one's
not to
different,
be.
but still, I would.
Each one
tend to
different,
agree.
but it would seem to me not to be the thing to say, well, we're going to apply this by the letter. You know, how does that help anybody? I mean, the idea, the whole idea of the ordinance is the health, safety, welfare of the community. How does that help anyone? Doesn't help anybody.
And that's one of the reasons you have a zoning board, is to make these interpretations. Perhaps a portion of it, if you feel that the benefit, to me, outweighs the letter, maybe it should be worth consideration.
I agree that we need to meet those criteria, but I think they can be met by looking at the building as a special condition.
How,
I may ask you then to write the opinion, but
Don't do that.
the distance requirement or the setback requirement that is in question is the 6 foot 6 inches?
Well, the
The whole building.
the whole building.
The whole building itself is, yeah.
yeah, the whole building is, or almost the entirety of the house is within the River Conservation District.
Yeah.
Raises the question of how that happened, but I don't think that's before us.
Is the
Well,
whole,
the
is the
river- the
whole
river-
building in the River
The
Conservation?
River Conservation District is not a setback requirement, it's a use requirement.
Well, yes, so you can't have this kind of use within the River Conservation District, I agree.
Unless, in other words, if you read that ordinance, unless it already exists or
Grandfather.
not even grandfathered, but that the ordinance seems to, that particular ordinance, when I read it, the River Conservation, seems to allow a lot of outs for the structure, as long as it's a permitted use in the area. And it is, I mean, the house is a permitted use in the rural residential.
Yeah, but we will be adding a structure in the River Conservation District, it's new porch.
Are you saying that you could increase, if you had a house in the River Conservation District, which this one is, and you decided you would double its size, that you could just do that?
No, I
Because
don't.
it's, well, then that's, so if you're going
But
to
it-
increase the nonconformity, certainly, that would be a question, right? In this case, they're going to reduce the nonconformity,
Right.
but if they were increasing the nonconformity, now, why don't they put the screen porch on the back of the house, which isn't in the River Conservation District?
We just put an addition on that side.
Oh, I see. Okay. I get it.
Martha, you've been silent, any comments?
Yeah, you're talking about there's nothing in the zoning, and I'm thinking there is in the zoning somewhere mitigating, where if I have a house here and I have land someplace else, I can use that land as acreage from my land over here, or I can have, offsets.
Mitigating.
So it's possible to have offsets from lot to lot. Why not within the lot to have offsets? It's just not dear.
Right, yeah.
Okay,
The other thing is that, as a general comment, if you look at the new handbook and some of the land use regulations, the courts have been moving the state more and more toward the rights of the owner. It's shifted a little bit over time. It seems to be moving in that direction. Now, that's just a general comment that has, no real bearing on this case.
We still have criteria that have to be met.
Sure.
just question is how, I mean,
Again.
Well, from a
it's-
conservation,
it-
I really feel strong about getting rid of that porch on, close to the water, that, from that perspective.
I think
not
it's
from this board,
improving
but yeah.
what's happening. I mean, if you deny it, you're gonna have that deck still there,
Yes.
okay? Instead of a smaller porch,
Or-
out of sight.
Yes, I don't disagree. Well, it sounds like I'm in the minority here. Shall we, I think, from what I hear, I think there's enough to have a,
One question on this. Is the hardship the fact that the river is there? I suppose everybody, no, take it back. 'cause
You get too
everybody else has-
philosophical now.
Well, no, I mean, now they put it on the other side. I assume nothing was there before and they just came in looking for, I guess, a deck. And they're asking what is unique about this piece of property. And this piece of property is, they can't build it in their backyard because it's sitting on a river.
but everybody else along the river has the same problem.
if they're
Yeah.
within the river conservation.
Yes.
Yes.
Jerry?
Non-conforming use, this is 5421. Non-conforming uses which existed on the effective date of the section shall be permitted to continue as specified in the zoning ordinance. Lots that are partially or entirely within the River Conservation District and qualified as building lots, which this does, designated on a plan approved by the planning board and recorded in Carroll County Registry of Deeds, or separately owned at the time the section takes effect and which cannot particularly be enlarged to comply with the regulations of the district, may be used for any purpose permitted within the underlying district. Such uses shall, to the maximum extent, only to the maximum extent, conform to the spirit and intent of the section.
When did this become a separate, this wasn't always a separate lot, was it? I mean, when they subdivided it.
Woods subdivided parcel here to increase this Stamey property.
Right, because that
And it
used to be just a
Kane-
cottage that
Kane
went with the
Christie.
other house, right?
That was all part of Woods' lot.
And when's this section take place?
This is River Conservation District, Section 5, purposes and intent. The purpose to protect and maintain existing
Do we have a date on that?
I think it's 1988, or thereabouts.
3/10/87.
Okay. Yeah.
Now again, the house was built there in 88, I think.
Yeah.
So I'm not sure how the house got
Yeah,
there.
I just wondered, I'm
But
curious.
But it's there.
It's not relevant at this point for us,
Well,
I don't think.
Why don't we bring
I
it
just think to meeting the concept of, to the extent possible, he's making a use more or less non-conforming than what.
I don't disagree.
But the question is, what's
My point is,
the
I don't see-
uniqueness, what's the special, what's the
I
hardship?
don't see I don't see it meeting that last problem, though. I mean, I think it'd be a good thing. I'd like to see the zoning ordinance changed to allow something like this. I just don't see how we do it via variance. But I think I'm being about to be outvoted, so it doesn't matter. Why don't we start, since we're talking about hardship, I think the rest are going to be easier. I suggest we take this for a vote to see whether or not we think of that. The applicant has demonstrated that literal enforcement of the provisions of the ordinance would result in an unnecessary hardship, meaning that due to the special conditions of the property that distinguish it from others in the area, there's no fair and substantial relationship between the general public purposes of the ordinance and the specific application of this ordinance to that property, and also that it's a reasonable use. All in favor that the applicant has met that standard, raise your hands. Okay. That was 4-0. I'm voting no. Then why don't we go, since the application has changed, I think we should go back and look at each of the other criteria.
Yes.
Again, the first is that the variance will not be contrary to public interest. All those in favor, raise their hand. I agree. That's unanimous. The spirit of the ordinance will be observed. Agreed. Substantial justice is done. Agreed. The values of surrounding properties are not diminished. Agreed. So we've just voted that they have met all the criteria, so the next step would be for somebody to move that we grant a variance.
Can I just add before we do
So-
that?
Yes.
I move we grant the variance.
With conditions? That it can never be built?
It's already been moved.
Well, you can unmove it.
Well, they couldn't build it.
They
again,
couldn't
so
build it,
yeah.
yeah.
They couldn't do
They have to
that.
come
Yeah,
back.
and for a
People
building.
do. I'd like
What
to see it in the
conditions are you
deed.
suggesting?
There was always a screened porch and is written into the deed. Because we just have too many things in town that people forget about.
You mean
Over
that-
the years,
that-
20 years when I'm gone.
That it can't be converted to what?
Living space, a permanent living space, and however you say it, they can't build a knee wall, and all of a sudden there's windows, and all of a sudden it's cold in the spring, so we put glass in, then it turns into a room.
Why would that be a problem if
Yeah.
that happened 20 years ago?
Well,
Well, they'd have, your point is they'd have to apply for a building.
Yeah, that's what I
Yes.
just
I
said.
understand.
Yeah, they got to come in for a building permit.
I understand.
I know what you're saying, Mark.
Am I correct in interpreting what you're saying is you don't want to turn a porch into living space?
Right.
Is a porch not living space?
Year-round living space. How can we say, you can live in it in the
I
winter all
don't
you
think
want.
that has nothing to do with what we're
I don't know
deciding
why
here.
that-
Nothing.
Okay.
It's a problem.
I have my motion. I move we grant the
Second.
variance. Second. All in favor?
3.
Opposed? Two.
Did you vote, Martha?
Did you? Abstain?
I vote for with conditions, but I know.
Okay. Had 4 in favor and 1 against.
He
So-
understands.
The variance then we voted on, and it has been granted. I'll try to write up a decision, but I'm going to need some help on how exactly this.
I think your point, the point you made formally about seeking a change to some of these things, and this is just an aside, if we visit something often enough and rule on it often enough, then maybe that is time to discuss changes.
Well, as you know, Bob Thompson has suggested a joint meeting, at least of the chairs, but I certainly invite everybody here.
And I suggest your point's well taken.
Yeah.
And I will, I do think that having the ability to swap non-conforming uses, either maybe as a special exception that requires looking at it, but something the planning board should look at for sure.
Good. I concur.
Okay, with
You
that,
know, by the way, just a point of
Yes.
interest, did you see that the zoning, the planning board just had and passed a change in our zoning ordinance that recognizes the problem we had with Rupel and
The
problem
corner
we
lots,
had with
yes.
others, right?
Yeah, I saw that. That was.
and
I'll save Jerry's letter.
Well, there's,
I'll share, I wrote it, by the way.
But they decided it was better to do it the way we allow.
Well, and I think Jerry knows this. I did, on my own, not representing the ZBA, write a letter to the planning board outlining 3 or 4 ambiguities in that ordinance with the suggestion that they fix it. For example, what happens if you have a road that goes like this and goes like that, but it's the same road? The way that might be a corner lot, but the way the ordinance is written, it suggests they should be different roads.
yeah.
There's all sorts of things like that.
I concur
And
entirely
Bull
with
River was
those.
another one.
Yeah.
We knew we probably couldn't
The,
avoid.
the points you were making with respect to that were, I thought, right on target.
And so we might be, well,
Anyhow,
so,
I was glad to see that fixed then.
Yeah.
okay.
Yeah, I
Okay.
noticed
Thought
that.
that was good.
Will you help him in writing the decision?
Actually, you're pretty good at it.
I am. I've got somebody that can really help me.
Yes. Okay, well, I will officially close the hearing on 10 Candy Cane Lane, or 20 what?
10.
It is. And we have
Your
second.
condition is inherently written into this. Your condition is
Thank you.
protected.
Take care. I will open
Your condition that you
the
wanted
public hearing
versus permit. I understand what you
on 200 Tin Mine Road, which originally took place on February 4th, was continued to the 25th, and now continued to tonight. And we have,
The next one,
ladies and gentlemen, we're on a new case now.
Okay.
Have a seat.
Hi, everyone. Hello. Again, for the record, I'm Chris Meyer. I'm here on behalf of the owner. The owner is here with me today. Dave Caldwell is here in the back if anyone has any questions. But we were here last time, and my understanding was that the board had at least thought favorably on this variance on all the conditions except the hardship condition, the same issue that occurred in the last variance you heard tonight. And essentially, it was about what the special conditions of the property were. And I would first, I suppose, emphasize Mr. Mason's point in the last hearing that the Supreme Court recently has talked about what special conditions are, and it's not physical conditions of the property, but really how the ZBA and the zoning ordinance treats different properties. And special conditions are this property is treated differently under the ordinance rather than this property is physically different than other properties that are in the same district in the ordinance. It's treated differently than other properties in the ordinance. And that's essentially what we looked at in coming back to the board and talking about what the special conditions are on this property. I talked to, and we hired Doug Brunell, who did a lot of the original permitting up in this area, and talked about why this property might not have been built out like all the other properties in the area and up along this road. One of the points that the board made last time was that there are other properties that are similar to the lot that the owner is seeking to build out here and seeking to put the porch on here. I suppose for the members of the board that weren't here last time, this application is seeking to extend 5 feet 8 inches into the front setback, which is a 50-foot setback. It's a porch that goes on the front. It's a wraparound porch that attaches to the porch on the back of the property. But essentially, in talking to Doug, we looked at how this property is different, and really the first thing that he looked at was this is the only property in this row that's not built out. The other properties, as we discussed last time, have been built out. The 2 properties on the other side actually have extensions into the front setback. The property on Looker's left to this property has a porch exactly like this property that comes into the setback.
Did they receive variances?
No, I believe that they were grandfathered.
yes.
So I actually haven't gone back and looked through the entire file as to both those properties, but my understanding, and I think the board's understanding, was both these were grandfathered. And one of the reasons this property wasn't built out, it looks like, is that there's two different issues with this particular property. One is that if you look at how the road comes up, how the road's platted, and I don't think Doug platted it, but he has the original plan, the road is not in the center of the right-of-way coming down Tin Mine Road, and I think at the point it was platted, it was Profile Road or something like that. But so in terms of how this property is affected by the setback vis-a-vis the other properties on the road, is that the road here is closer to the right-of-way edge than, or the road here is further back from the right-of-way edge than other properties. So if you are looking at the property from the road, this property looks farther back. So it is affected differently than the property next door, who, if you're driving down the road, even though you have the same incursion into the setback, that property will look farther into the setback. This one would look farther back. So here we have a different impact because of how the road affects this property versus the different, you can see how...
Is that
you can-
evident on this?
It is. You can see how the road fades away from the property as opposed to the one north of it. This property right here is the other one that has the porch on the front.
Yeah. Okay.
Is the red line the travel road? Is that what it is?
Yeah, I believe the
Dotted
red is the
line.
traveled road and this is the right-of-way. So it looks, it's not substantial, but it is a different effect on how you're looking at the property versus the right-of-way.
Don't you have a legal survey from someone?
That's,
That's from
What this
Emmett. The second issue is that while there's not a legal wetland on the property currently, historically there was a stream that ran across the property that hit exactly where one of the things the board was talking about last time is why don't you put the porch on the northern end within the building envelope. Historically, there was a stream through that northern edge of the building envelope that might have precluded building in that area previously. That is a special condition of this property that might have precluded the build out of this property prior to, like the properties on either side of it. You had one property on either side of it that was built out prior to zoning. That wetland is a special condition of the property that quite possibly may have precluded building out the property prior to grandfathering. The third issue, and looking at how this property is unique in the way zoning impacts it, is it is the only property on the street that is a unbuilt grandfathered lot. You can see the building envelope, at least in terms of front back, that built out to the entire extent of it. The other properties needed to get within the current setback to actually have a house and be built. This property is impacted essentially because it wasn't built out prior to zoning. Again, if you look at zoning or special conditions, how the current Supreme Court is looking at special conditions, it's not a particular characteristic of the lot, but how zoning affects that building of the lot. Being a grandfathered lot in and of itself is a special condition of the lot, as I think you determined in the last zoning case, that affects this lot and requires that at least gives it special conditions that a zoning variance might be appropriate in this case.
Are you saying that this lot has special conditions because everything around it was built out before zoning, and then zoning came along and couldn't do what other people did, so that's a special condition?
Correct.
Then that would seem to say that any time you've got a lot that hasn't been built and now nobody has to, around them they've built, then you don't have to worry about zoning because you got a special condition.
You do have a special condition because you are grandfathered, but here you have a unique case where every other lot around you is built out within the setback. So that creates the special condition. I agree that is, well, it's unique. It's unique for here. If you have a lot that's like other lots in the area, but those lots in the area that are already built out, whether because they got a variance,
No,
or whether
before
because
zoning.
they're grandfathered.
Pre-74.
Yeah.
Then you're unique because special conditions aren't because you have a particular physical condition on your lot that makes it different than this lot and this lot. It's the special condition on your lot is you're like these two lots, but you weren't built out before zoning. That is a special condition of it itself. And frankly, I don't think that applies to that many lots in Jackson such that it would erode the particular conditions of the zoning
No,
laws.
but that's really what you're saying, is that if
Well,
you own a lot and everybody built out around you and they didn't meet the current zoning ordinances, then you got a special condition, you probably shouldn't have to meet them either.
That if,
Exactly, that's exactly what a variance is for, is that everybody else did the same thing. You are a special lot because you didn't build out before, and there's other conditions of a variance. This isn't the only one. You have to look at whether it meets the public interest, and whether it's good under the zoning ordinance, and whether it's a big
Would
imperative.
this be true of all the unbuilt lots on Chin Mine Road then?
If
Because
there were other lots that the abutters came into that were looking for a similar variance that were.
Then we just give it to them on this basis?
no, we don't
You have
create
to
precedent.
say that it meets the public interest as well.
Yeah, we don't
But-
create, there's no precedence.
As I see it, the special condition is that this lot, because it, under current subdivision rules, would never be subdivided into a lot.
Right.
However, this is a legal lot. The house would be limited to basically 28 feet of space of the land,
Yes,
and the special condition may in fact be that.
correct. You have that's one of the things that I've listed is, I listed seven different, and 8 is the confluence of all of them, but one of them is, yes, it does have a small building envelope because it's a substandard lot, and that, in fact, in and of itself is one of the special conditions that allows for a variance on this lot, in addition to it being closer to the road versus the other ones, it having a historic wetland on the property, and the other issues.
Isn't it wetland now?
No, I think the stream dried up, and not anything that my clients did on the property, but I think the stream dried up elevations
So we moved it
above.
It may have been a seasonal runoff that was redirected.
Yeah, runoff.
And-
But that the special condition was that historic wetland might not have allowed the lot to be built prior to the zoning ordinance coming in, like the lots around it.
So you're saying even though it's a wetland, we can actually add building size to it, which doesn't.
No, it's
make
not.
No, it's not a
It
wetland.
was, if you're
It's
going to
a-
say it, so it, yeah, but
It
you're
doesn't
saying-
matter whether it was or
We're using
not.
that in one direction,
It's
we'll
not-
use it in the other direction.
It's not now.
It
Yeah,
used
but it
to-
was, if you're going to call wetland and say something was or is,
I disagree.
Well,
Right.
he's saying that perhaps that's why this lot wasn't developed, because they could see there was a stream running through it, so they didn't develop it.
and I'm saying if the rain increases by 40% like it's supposed to, with climate change,
Yeah,
it's
but
going to
if-
turn back
again.
into one.
But if that's a pretty big if.
There's no
Yeah,
current wetland on
okay,
it.
all right.
They
So
did a lot
there's
of
something wrong about saying we're going to increase a wetland, it doesn't make a lot of logical sense to me.
What I see, he's sort of reaching at straws with the wetlands concept.
Thank you.
It is not a wetlands.
It's not a wetland currently.
Yeah,
But
full stop.
but there
That's all
was-
that matters.
It has a cliff, yeah,
I understand your point, though.
thank you.
Is this porch already built?
Yes.
It is.
It is. And how did that
That-
happen?
My understanding is that happened, they built it, they didn't know that it exists, they had advice from, they had
They had a
the,
building permit, didn't they?
Yes. Yes, Kevin. Building inspector.
Oh, building inspector. They had a building permit, right?
What happened there is, I came on to the job in the middle of summer, and I think at that point, the footings were being poured, and the concrete walls were being poured. And we actually went up there, and I was on the job, and we went up there and did an inspection. And anyway, at no time anyone mentioned anything about this extra porch being built. So anyway.
Because there were plans submitted with
There were
it.
plans, but the original plans never showed this porch. And from what I understand too, I guess there was 2 set of plans floating around too. There was another set of plans with the porch showing, because this went out to bid to a couple other builders who looked at it, and the porch was on there.
But those weren't the plans that
Those
we
weren't the
had.
plans. So the plans that were submitted and approved was the house without the porch on it. Then, doing my inspection, going around town, I drove by, and I noticed this porch extending off the front. And that's when I stopped and I said, hey, what's up? And I knew, and I'm just thinking here, me and Goody and the architect who drew the plans too, I mean, he knew that, he was building in the setback, or even drawing in the setback. So anyway, I stopped in, and Jeff Mallett, the builder, and I asked him, I said, I think there's a problem here. Could you stop building this until we figure out what's going on? And at that time, he said, no problem, I'll stop building on it. Well, I went back to the office and started doing some research. And basically, I stopped up there. This was early in the week, and I stopped up there, I think it was a Friday, and they were continuing, they were still building on it. So I said, hey, Jeff, I got to go down to the office and write up a stop work order and issue to everyone, you got to stop working on this. And that's what happened. But at no time between the footings going in and me catching them building that porch said that this was an extra going onto the plans that we were going to build this this addition. I think they had plenty of time to do that, and I don't know. Jeff said about the plans. He said this is a set of plans I got, and this is what I'm building. And then I said to him, well, I told you to stop building, because the porch, because of the setback, and you continue to build. So it's definitely an issue there.
Actually, as distasteful as that sounds, that has no bearing.
Yeah, just going to say, that has nothing to do,
Yeah.
nothing to do with
Right.
us.
And I would argue that it has, I'm here with the owner here today, how that impacts the owner versus his builder is different. The owner was not involved in that. The owner is advised by professionals that live up in the area. The owner was advised by, I was not involved in that. I was not involved in the project at that period of time, and the owner was involved. It was being advised by the former building inspector of Jackson. So, to the extent he got bad advice, it shouldn't impact his application to this board.
Oh, it does. It doesn't. I'm just curious.
Well, since this is not relevant to the decision,
Then I just got irrelevant information.
so
Thank you.
well, it's interesting information, but not something that we can concern ourselves with. Any other questions or comments?
Not yet until you go through them.
Okay. So the reason the special conditions we're talking about are a differing right-of-way, a different travel way for the right-of-way.
There's 7 in my application. They're listed if you would just want to
Okay.
copy that into the record, but it's being a substandard unbuilt lot. It's a grandfathered lot of
That sounds like a stop.
.036 acres. The building envelope is only
Just
25 feet by
figure.
75 feet.
And why is that a special condition?
Because
Building up.
it's a special. It's different than the lots around it. It's different than the other unbuilt lots around it. That it has a smaller building envelope than other lots within the district.
But other lots of the same
It is-
size would have similar restriction and.
Correct, but this
buildable
is an unbuilt lot.
area. Okay.
And for the purposes of special conditions, it doesn't have to be unique to every property within the district.
No,
It just has to be. It just has to be different.
I'll make sure I understood what you're saying.
Right.
What is the size of this lot in relation to the lots around it?
The two on either side are the same.
Oh.
There are other lots up the subdivision,
And what
I would
you-
say,
understand.
but most of them are.
They're all right
What he
around
was
the
referring to was that these were built
I
pre-73.
understand
Yeah.
that, yeah. I understand.
There's a whole strip of lots, all parcels, all about the same size.
Yeah.
Yeah.
Along that road. Now, across the street, it's, I believe the lots are relatively larger. I think that's what Holly Lewis is about.
Who still needed
Yeah.
a variance.
But this strip,
But there are also on Tin Mine, that development, there was something like 200 and something half-acre plus or minus lots all over the place.
here, to
Under an acre, let's call them under an
to
acre.
answer Dave's question, this is from the original application. You can see on their side of Tin Mine Road, I'm sorry, their side, yeah, it's Tin Mine Road, you can see.
Yeah, I see. There's lots of .36,
Yes.
Yeah.
0.7 lots, right?
The three in a row, they're
Three.
like .6.
Basically lots that would not be permitted today.
Today.
Yeah. What are the rest of his,
Go ahead, I'm sorry,
Second
I
points.
interrupted you, you were
Oh, sure.
summarizing the points.
The building envelope was the second one. This project is they're looking to put up the first LEED Platinum certified home in Jackson, and I believe in the area. It would be a zero impact home. They're looking to make it essentially zero impact on the grid so that it produces more energy, or at least as much energy as it puts out. The angle of this home needs to be in the angle that it is to catch the azimuth angle of the sun. It's got solar shingles on it, and that's why it's configured the way it is. The fourth condition.
But wait, but why would that? What has that got to do with the presence or absence of a porch?
It's part of the alignment of the house. If you look at the neighboring lot, to bring the first floor up to the grade, all these lots drop off down the slope. So the configuration of the house on the lot has the shingles coming down on one side of it and needs to have the porch to come up to the grade to access the house. So the entire configuration of the house, based upon the building envelope and how you need the slope of the house to come down, requires this configuration.
Struggle with that
Don't
because
see
the
that.
original.
Yeah, the
I don't
house,
see that at all.
if the house is pointed in the correct direction, then what does the porch have to do with it?
Because the porch is on the side of the access.
Are you
I
saying
mean,
that
you
this
could- you could
wouldn't
put
work
it on-
at all without that extra square footage?
Yes, it would exist without the extra square footage, and you'd have to have a ramp up, you'd have to have the thing drop down to access either the lower level, or you'd have to have something come on off the side, but it doesn't work as well with that.
So this is really, you're saying that because of the lot, you need this porch for ease of access?
For access. If you look at the next side, if you look at the property right next door, it does the same thing, so that they can go into that level of house.
But the portion of the porch on the other side of facing the house,
On the Tin Mine side.
the existing deck,
Oh, you're going back.
which you can see the existing deck,
Yeah.
which was part of the original building permit, had stairs
Right.
to give access.
Stairs, but we went through how there's last time we went through how that two of the parents that use the house have disabilities and can't come in stairs. So
But there's stairs
Part
to
of
get
the-
up on
Stairs.
this porch too. I mean, the porch isn't flush with the ground level.
I think the front porch is flush with the ground level, and or it's at least
Yeah.
less stairs to get in. I mean, the stairway you have on the original plan is 6 steps up, rather than one that's more flush on the front.
Yeah, as I recall, it was like 1 or 2 steps on the
Have
front.
we all gone up and looked at
That's
it?
the
Yeah.
Yeah,
I'm sorry?
I was just wondering if we all physically saw it.
yeah.
I've seen it, but I haven't seen them, how they may have changed the grade by filling in afterwards, or if they have.
Well, again, you can't fill in the grade right to the foundation, or you have runoff issues. So you fill in south, and then you use a porch to cover over the grade that goes down to the foundation.
Okay.
I just want to see that.
Any other comments or questions?
When you start to go through the prongs, I have one comment. relative to the spirit of the ordinance.
Just,
Shall I, well, go ahead, Martha.
what's the square footage of this house again?
It's not big, it's kind of small.
It's about 25 by,
Yeah.
Yeah, but it's 3 stories.
still,
How many bedrooms, 2 or 3? What's the,
it's 2, because you can't get,
You couldn't get septic approval for
Yeah.
3.
big house for 2?
you also took the-
Here, this might be helpful in terms of the picture. That's from Tin Mine Road. That's one of the pictures that Kevin took. You see the deck off to the right, which
It
is in the
affords-
setback. But it is
We did
not in the
restore it.
prescribed setback.
We allowed him to expand the non-conforming.
and that's the deck that was on the original drawings?
For egress. And this-
Yes,
this
so
certainly allows for
what's
that.
happened is, as I understand it,
I think
there's
looking
a
at the property, it looks-
an additional covered deck on the Tin
It looks a little
Mine,
shaky.
Tin Mine Road side of the house that wasn't on the original plans. And that's some
Which I think he's-
portion, substantial portion
Stop
of
this
that.
conversation
Yeah.
over there.
Martha?
Yeah, can I see that?
Yeah, you've seen it. It's, yeah. Well, Ed, I'm sorry, Chris, I guess I'd ask you to step back
Sure.
and see if anybody else has any comments at this point.
I note there weren't any abutters there last time either, and we understand that the abutters are in favor.
How do you understand? I have not heard anything about any of the abutters.
The abutters have similar portions.
Oh, no, I thought you were making a statement.
I haven't personally spoken to
Okay.
any abutters.
I think relative to abutters, the question is whether or not it diminishes their properties in any way.
And nobody's made any argument to that.
Correct.
So I think I'm comfortable taking the applicant's, I would suggest we can take the applicant's statement that there's no diminution in
Right.
property values. And I know of none of us personally have, I think, can think of a reason why that would be the case, but we also have 2 professionals in the audience who we could speak to if we had to. I'm not sure we need to. Well, I mean, I guess I still don't. I have a hard time with many of the arguments on hardship, especially that it's a hardship because this was unbuilt when zoning was adopted. I mean, I'm being a little bit flippant there, I understand, but I'd be very uncomfortable supporting a variance for that, whether a major pillar of the demonstration of unnecessary hardship. And I also don't think that the traveled way on the road is substantial enough to have much meaning, but kind of going through some of his arguments, not all. So I guess I'm kind of, but go ahead, Jerry.
The comment with the traveled way is that the setback requirement of 25, 50 was done in a special town meeting in 1974. And the planning board struggled with what they wanted to do was create an open space. And the RSAs in the state did not provide for that. So the attorney was Upton at the time suggested that the proper use of a setback, and was publicly stated then, was to allow for adequate snow removal, off-street parking, and future road expansion.
Well, actually, let me step back for a second. The setback, of course, is from the right-of-way, not from where the travel way is.
Well, and that would stand for road expansion.
Right.
Because they've got
Would
the
make-
right-of-way, you can expand into that right.
So it gives them more room to expand.
Right, but I mean,
to that north
that was the stated purpose of the setback. And I don't see how this, for that prong, has any effect on that. In other words, he has a driveway and a parking area that it's going to be there regardless of whether he has the porch or not.
Mhm.
So it's not going to affect future road expansion, snow removal, or access to of emergency vehicles.
Yeah, but if those are the only purposes for the front setback, why do we have a 50-foot setback from the
That's
property
why. I mean, that was the stated reason of the setback.
But doesn't 50, I don't want to rehash history, but 50 feet seems a little excessive to give room for snow removal and,
But and what I'm saying is that was the cloak under which they did it. It was
Understand.
because they weren't allowed to use the concept of open space.
Is that,
I see.
is that, do
And,
we have a record on that?
and relative to the adequate road expansion, snow removal, and access of response emergency vehicles, right across from our fire station, we have a structure that is well within,
Oh, yeah.
and so and there's no effect of it, or there's no problem with
I
it.
guess I'm struggling with,
So
trying to connect the dots, what you're
what I'm
arguing.
driving at is the spirit of the ordinance is met in this.
So you're saying the spirit of the ordinance, or the purpose of the ordinance is, as you stated it?
Well, not me, the planning board.
Well, and is that the minutes from their meeting? or-
Right.
But that's another prong. That's one of the,
Yeah, that's what,
Okay, spirit.
that's it.
Yeah.
And I get that you're struggling.
The thing that makes me uncomfortable, I think, is the same thing that makes you uncomfortable. We've got this theory of hardship or uniqueness, which is based on, I'm building now when there are zoning ordinances and everybody else built before and there weren't any. Now, Chris may be absolutely right. And he says, now the Superior Court, they now say this. Well, I'm not an attorney and I don't study the Superior Court, so I don't know. And I would feel a lot more comfortable if we were going to accept that argument, or thinking of accepting that argument, if we had some guidance from our own attorney to say, is this accurate?
that's what I said at the last meeting.
That's, in my mind, that's what we ought to be doing.
Well, here's the latest on that.
I don't
Values
look
of
at
surrounding
just those
properties,
three
not
houses
diminish
being the
what we're
neighborhood.
talking about.
I'm sorry?
I just don't look at those
So-
three houses. I look at Tin Mine Road and the number of sub-size units that have not yet been built. There's quite a few still up there that people have hung on to, if not exactly in Tin Mine and Juniper and the whole area.
I don't hear anybody on the board making statements in favor of the applicant having met the hardship test.
I find it architectural review is more, is this pretty enough? Well, that's not our job.
But
That's
that
what I
wasn't what I
see
was
here.
asking. But
Well, that's the arguments I'm hearing. I'm not hearing hardship.
No.
Well, hardship can also mean uniqueness.
Well, again, I think what we're after here is,
I see it. Absolutely, I see what that says. I'm just really uncomfortable with saying
what
that
are
the
you?
uniqueness is that everybody else built before.
Frank read that, he knows.
Everybody else built before.
But my point is, there's a whole bunch of houses that are built after, so they're all undersized lots. They're all
Give
an
that to
acre or under. So can they then, this is not unique, it's not the
Yeah.
only substandard lot. There's another 10 or 15 up there. So they're not unique on that argument.
Well, and Chris would argue that they all ought to be entitled to a variance.
But
if
that's
they're
a
not
planning
allowed to
board
purchase it as a
change,
setback.
it's not our, then it becomes a planning board issue.
Well, Yeah, let's not put words in Chris's mouth. But
I think that's what he said.
I would argue that it doesn't need to be the only lot. The Supreme Court is very clear on that. It does not need to be the only lot.
I'm not,
And some of them might qualify, some of them might not. It's whether they meet all the criteria. The hardship criteria, all those lots might be. And I would suggest that you just found on the last one that the only special condition on that last lot was that it had a pre-existing
We're not going to argue with
porch.
that last lot.
But-
Each one is individual.
I understand, but you've got to be fairly consistent because that's what following case law is about.
Well, it's not case law. We
We're
didn't
not
just say
lawyers.
case law.
let's not get into a argument or conversation on this topic. Yes, Jerry?
Is it Chris?
Just
Yes.
I would just like to hear, in as concise a way as you can state it, what is the uniqueness of the property?
uniqueness of the property, it's a small lot. It has a small building envelope. It is not built prior to zoning like the lots around it. It's on a slope that requires a porch to get up to grade, whether you have the house at grade or not. It has a historic wetland, so you couldn't build in the building envelope prior to zoning. If you look at when that wetland was on the property, it was in the time prior to zoning. It had a wetland up to, I think the map I had was about 2000. So you couldn't build in this building envelope prior to 2000 because there was a wetland on it. It's close to the road versus the other properties.
Not to put words in your mouth, but could the uniqueness of the property be the slope of the property that requires an egress built into that 5-foot area?
It is, and it's shown by the properties on either side of it that have that porch on the front
For proper egress?
for property egress.
Correct.
Thank you.
Yes, thank you.
Who would argue that they have met the criteria for hardship?
I would argue that they have met the uniqueness criteria, that they need that 5-foot to establish proper egress to the home because of the slope of the law.
I wouldn't argue that they didn't, but I would like to hear from our legal counsel, because I think I know these cases don't set precedent, but this is a very interesting approach to establish a hardship. And we've got a lot of that. We've got a lot of lots like this, as Martha has said, in town. And it would be nice to hear from our counsel to say, yep, I think that's right on the money.
So we're a little smarter next time we're in.
Well,
basically.
exactly. Now, the applicant comes here with an attorney, which is great, and the attorney represents the applicant and is paid to represent the applicant. That's why you have attorneys in situations. Everybody has an attorney, not just one attorney, telling you what the Superior Court says and what establishes the hardship. And this is not crystal clear to me. I've never thought of anything like this before. So I would say I wouldn't vote against it. I would vote against it tonight because I don't have the information I'd like to have, the corroboration of this being what the Superior Court has said about, or the Supreme Court has said about uniqueness and hardship. That would be my
So you would suggest we continue?
I would continue it. I would get our attorney. I would have him review it, review Chris's list of reasons why this is a hardship, and
Get his paralegal to go through the court cases.
I would take.
Yeah.
I would like to hear what he sees.
And Martha or Dave Tusky?
I made that point last week, or last session, that I thought that a review by Mr. Malia would be a good thing.
If you turn it down, he's going to take it to court, so he might as well take care of the headaches now.
Well, I'm not ready. I mean, it's
a little too
if
frank.
we have doubt,
A little too
if
frank, but
there
that's
is
how it comes
doubt,
out.
then it probably does make sense to. I mean, I'm ready to say no tonight, but I think I'm not.
I'm not happy with this at all. I'd say
But
no tonight.
I think there's enough people
So you would
who
vote no?
either
No.
would be inclined to grant it, or at least want information from our council, that I guess I'd entertain that. I mean, I entertain a motion that we do that we continue and.
Well, I would make a motion that we continue the hearing so that we can get advice from our council.
Second.
Let's not make it too long.
All in favor of taking that action? I mean, I want to make, Jerry, I want to make sure you're also in favor of going this direction.
Apartment?
Going in this direction. Would you support Dave's?
I guess permission to speak freely?
Yeah.
I don't. I think that the decision is ours. I think that, I mean, I don't want to attorneys very often give you both sides of an issue and then say, you decide.
Yes.
And I think it's pretty clear that we have both sides of the issue tonight.
Well, I think it comes down to, would
And I think Dave was pretty clear when he said if he voted tonight, he would vote against it. And I guess I'll wait to see what the decision of the board is.
well, I'm in the interest of doing that. I would like to see finality as well, but I don't want to run roughshod over Dave and Dave's
We have a
feelings.
motion, right?
We do.
Seconded. Then let's vote on the
Okay,
motion.
all in favor of continuing the hearing to gain input from our council? Please raise your hand. Opposed? Okay.
Okay.
We may get back to it. Can we then try to make a decision on whether or not he has demonstrated hardship and met both parts of the hardship test, which I'm not sure I need to read again. Maybe I should.
Let me,
Again,
Go ahead.
Frank, one question on that. Are we denying him the use of his property?
No.
no, he hasn't.
No, you're not.
Okay, because
They
that to
have
me
a
is
building.
really important.
I mean,
They have a house, they have a porch, they can do entryway, they can park.
so
So
again,
They don't have a porch. If,
They have
They have a
3/4 of the
Right,
porch,
they have a deck.
3/4 of it.
but not a porch in the
to
front.
be clear, if we rule tonight against this, then assuming other things are in place, he will have to remove the porch.
Yes.
Yes.
I think we all, well, it depends on the selectmen, of course, but, or the building inspector, I should say, but they would presumably order its removal, yes.
Okay. They're the enforcers.
So I'm going to ask for a vote on whether or not, well, let me remind everybody what unnecessary hardship means, that owing to special conditions of the property that distinguish it from other properties in the area, there's no, because of those special conditions, there's no fair and substantial relationship between the purposes of this part of the zoning ordinance and the application of that ordinance to this property. And second, that it's a reasonable use. All in favor that the applicant has demonstrated that there is unnecessary hardship, please raise your hand. 2, okay. All those opposed? 3. Okay. there are, because Dave Mason is new to the case, I think we should go through the other conditions, other tests, and make sure that we all feel that they have or have not been met. First is the variance is not contrary to the public interest. All in favor that the applicant has demonstrated that is not contrary to the public interest, raise your hand. 3, 2. I say no, and Martha, no.
I say no, it is contrary to
Okay.
public interest.
Number 2, that the spirit of the ordinance is observed. All those in favor that the applicant has demonstrated that the spirit of the ordinance is observed, raise your hand. 4, 2, Martha, 1, no. Number 3, that substantial justice is done. All those in favor that the applicant has demonstrated that, raise your hand. 3, and all those opposed, 2 against. 4, that the value of surrounding properties are not diminished. All those in favor that the applicant has demonstrated that, 5 to nothing. Okay, so it would appear that we have a majority that is unwilling to grant the variance, so I'd ask for a motion for granting the variance, and let's see how that vote goes.
Mr. Chair, I have a point of order. We asked for a disability variance, which also, if the board couldn't find, which they
Yes.
didn't find, that there was a hardship, the request for a disability variance takes the place of hardship.
Yeah.
If the board does not need to find disability, it does not need to find a hardship where there's a disability variance.
Yes.
It's found all the other conditions, so if it finds a disability, this variance is appropriate for disability concerns, then it can also grant the variance on those grounds.
And I'll get to that when we finish this. I was planning on doing that.
But it's relevant before you have a vote on whether the variance should be granted or not, because the board can also grant the variance based upon the 4 conditions that it found and that a disability requires or
Yes.
counsels for the variance.
I was going to treat that as a separate question. You're suggesting I should do that as part of the
Before
general
denying the
variance.
variance.
Right, because it would make moot the other.
Okay. Everybody's aware that there was a request for a disability variance. Why don't I review what that is?
Research that.
Well, let's be clear. So there's 2 parents that have disabilities. One of the disabilities is, I believe, skin cancer, and I think the other disability is cataracts, if I'm not mistaken.
Late-stage Parkinson's.
Sorry, late-stage Parkinson's. We have, and we're able to grant the variance to somebody who uses the property with a disability. We have the ability to grant that variance only for the life of that person, or for the period of time that that person is using the property, and then it'd have to be removed. Or we can grant the variance without that condition.
Could you repeat that, please?
Okay.
Because I haven't researched that part of this.
Okay.
I didn't know we were going to get that.
We can, let me read the, we are able to grant a variance without finding of unnecessary hardship when reasonable accommodations are necessary to allow a person or persons with a recognized physical disability to reside in or regularly use the premises. And the provision still requires the variance be in harmony with the general purpose and intent of the ordinance. And we are allowed to include a finding in the variance that those variances that variance shall survive only so long as the particular person has a continuing need to use the premise. Now,
And the extension of that is that at that time, the variance becomes void.
yes.
And presumably then, if there's a new owner or if parents pass away and it's the same owner, they have to come back in, I would presume, and say, well, you know, I need the variance, that one's disappeared, I'm guessing.
I'm not sure. I mean, it might be, we could also require as a condition that it be removed as a part of, if we want to go in that direction. Sounds like we're not ready to make a decision on this. Now, we've had
That's what
testimony
I
as to the
said.
nature of the disability. We haven't had any testimony on how often they intend on using the property. And, you know, since it's a new property, we don't have, I mean, obviously, my understanding is that this is, you know, meant to certainly accommodate putting ramps in and so forth for somebody who is, for an existing property. I'm not sure how to approach a new
Well,
building.
if you were building a property and you knew you had disabled people that were going to be using it, you'd build things to make it easier for them to use it.
Yes.
And that might require, on a building envelope of this size, it might require that you had to come outside the building envelope.
Yes.
So that's,
No, go ahead,
I
Jerry.
was just going to ask Chris if that's his interpretation of the disability variance, that it would go away.
Yes, it is. It would go away.
We don't have to make it go away, but we have the
Right.
power to
You-
make it.
You have the power to attach conditions.
I just wanted to know.
You have the power to either make it be permanent or that it goes with the property and it's an existing condition of the property that's better for people with disabilities, or you can make it go away based upon the person that's using it.
Right. And again, I apologize because I didn't see this coming or research it, but if, as you say, we make it condition that it go away, or we have the option of not making it go away, I'm trying to get my head around,
How we make that decision?
yeah.
I don't know. I'm not aware of a lot of case law on that or guidance from OAP. It's just that this is something that's there.
Can I ask a question? That would, at some point in time, it be possible with Parkinson's, knowing what I know, whatever that is, that you would need a ramp going over the staircase, further extending it into.
And it would be.
That would be possible.
We'd have to come back. But I don't know. You know, I don't.
Do you have much opinion on this?
no, I have not. Especially,
Well, I'm going to now, I think, go back to Dave's comment
Yeah.
that perhaps a continuation is in order, both to do more research on the hardship question as
This-
well as to look further at the disability. I mean, I will, my only thought is the original building permit design had this deck, and presumably that the architect had already taken into account what the needs are. I have no other way to try to make a decision on this.
I would ask Dave to make his motion again relative to the
Yeah.
continue.
I'd like to make a motion to continue this hearing, to give us an opportunity to research the,
As before, I second it.
okay. Do I need to say more?
What he said.
Should we ask for a statement from, before we act on that, a statement from the owner as to where the parents live and how often they expect to visit here? Is that relevant? Might that be
Well,
relevant?
what it says is for someone who resides there or who regularly uses.
Yes.
So what's regular use?
Right.
I don't know,
It
but
would be nice to know how often the parents are.
I guess that's pertinent, but again, that could be something that
well, before we talk to...
we don't have enough of information, I guess.
Yeah, I mean, I think I want to, let's use the opportunity now to get whatever additional information we think we might need to have a conversation with our council. And the only thing I can think of that might be relevant, besides knowing the conditions, are, where the parents live and how often they are expected to visit.
Yeah, then it comes down to the definition of,
Well, which we make.
yeah.
What I would like to further ask is the life of the condition, or would we want the option to make the condition permanent, or would we?
We have that option.
We have that
Exactly.
already.
Yeah. That's
So we can think
How-
about that.
Exactly. I guess that's what I'm asking.
Yeah.
I can speak to that later, I can speak to that now, but I will tell you that there's no case law on this.
Yeah.
This point, it's just not used that often. But I understand that the public policy is to encourage things that are handicapped accessible, so that the reason why they give zoning boards the option to make them permanent as opposed to just the life and disability of the current user is so that it encourages people to build accessible housing, and that it's in the housing stock, whether it's there or not.
Okay, so that's,
Interesting dynamic.
Yeah.
let's, is the owner in the?
Yes.
Okay, would you just quickly indicate where the parents reside and how often they visit you?
May I come forward?
Oh, yes,
Please
absolutely.
do.
The person with Parkinson's is my mother, Virginia Caldwell. She has been diagnosed with late-stage Parkinson's about a year ago. She is officially disabled by the state of Rhode Island and resides in North Kingston, Rhode Island. Blue sticker, handicap, the whole thing. Were this front porch to become, it has been designed to be exactly a ramp under cover. It will meet the 1/4 inch per foot by the building code, were that to be a ramp. If that became a ramp, would that change the caliber of this application?
No, I don't think so.
To meet the discussion point of hardship. They do intend on using the property. They are, in fact, heavily involved in the process of financing this, if you will. And this is just a place to come sit. On the north side, what we discovered is, and I'd be happy to explain how this came to be over the course of the past 2 years, if anyone would be so inclined, then perhaps to the Wildcat afterwards. But for the purpose of this discussion, why we're here tonight, I can give you some thoughts on where we are, and I understand the concerns of the board and where we're at. But that front porch that you see would perfectly accommodate a legal handicap ramp if you just sloped it right down to the dirt and got out and went up in that fashion. My mother is not in a wheelchair at present. This house has been designed with a first floor master suite, handicap shower. I think you see the floor plan to accommodate someone who can basically just kind of be quiet on our first floor. The porch is also the only spot on the property that's in the shade in the summer, and that's something that did arise this summer that we came to notice.
But if that were a ramp, then it would...
And that's why we're not in need of a ramp right now. We are able to get up a couple of stairs with some assistance. But were that to become a ramp, then it becomes a true handicap accessible property with a code conforming ADA ramp. That would make that, with the threshold clearance that we have in the front door, you would be able to have someone with a wheelchair utilize the property. That would be very easy to do. I'd certainly be willing to do that. I would attest anything to the board would wish in regards to zoning restrictions, plat restrictions. The inability to ever enclose it would be certainly applicable. The structure of the property does meet the setbacks for the actual building. The environmental regulations are followed. Everything else that I heard tonight to discuss about what these could be problematic in future zoning applications are going to be eliminated through many different aspects of other regulations that are in place.
I think I asked you up here just to kind of talk about your parents, not to kind of go into the whole thing again. unless people have questions.
But I found it helpful, thank you.
Yeah, I
Yeah,
think
thanks.
that's also, thanks.
Thank you.
We have a motion.
Yes. We have a motion to continue the hearing to our next date, and that will be the next regular date. If this is the 25th, it'll be April 15th.
Tax day.
Tax
That's the
day.
third Wednesday.
Yeah.
Tax day.
Well, first let's get the motion out of the way that we want to continue. All in favor of continuing the hearing, please raise your hand. Okay, we all want to continue then. Does anybody on the board have a problem with the 15th? That gives us 3 to 4 weeks to, well, 4 weeks actually, to get a hold of Peter and do whatever research we need. Anybody want to try and thinks we should try to act more quickly?
Well, the porch is already built.
Yep.
I assume the house is moving forward, so I guess there's really no rush. We don't have to do it next week.
I like that.
Yeah, we can wait till the next regular meeting.
Okay, good. And you're going to be, you're not leaving until later on that week or the 20th?
I'm leaving on the 20th.
Okay. Yes, sir.
I don't quite know how to ask this properly, but would it be appropriate to ask us how we feel about this aspect of the porch at this time?
Yeah, we can certainly.
Do we have any comments on that?
Oh,
My comment would be if he came in here and said, I'd like to build a ramp so that I can make sure that my parents will be able to get in and out of the house, I'd be saying hallelujah. But then we wouldn't be hearing that we need to do this because it's a non-conforming lot and everybody else built before he built.
Right.
I'm really uncomfortable.
So putting a ramp on it would make you comfortable?
Well, then we do it under disability, not under,
Yeah, or not.
you know.
How do you feel about that?
I guess that summarizes it pretty well. It's, I'm comfortable with it under disability, this disability argument, but not, if you were just saying, I'm putting this porch on and I want to make sure I have a ramp so the next buyer, that'll be a plus for me, you know, that, yeah.
Martha, how do you feel about it?
I just built an addition to my house and I made it wheelchair accessible right in off the street, and I really have a hard time with this whole thing that we're all going to get old and we're all disabled, and I've got skin cancer and I know half the other people sitting here do, and we've all got disabilities. This whole town is coming out of our ears with disabilities. Yeah.
But to me, that means nothing. So what?
So, yeah.
This is an
well,
individual case. I mean, who?
I don't know how to read that.
If
I see, if they lived here, if they owned the house, if they lived here, I'd feel stronger. I just have to, I got to think about it. I just have to think about it.
Okay.
It doesn't,
that's the way
it doesn't sway my heart. It's not, you know, everyone needs access everywhere.
if they wanted to remove the porch and put in a ramp, I'd be okay with that.
I'd be fine
But
with that.
to me, a ramp doesn't have a roof, and
Well, a ramp can have a
Have a roof, yeah.
because you got to keep
Well, how else are you going to get in the
keep
house?
snow off of it
Yeah.
and so forth.
well,
Nothing wrong with a roof on it.
okay.
If we made that a ramp
I have more,
instead of a porch,
the question I have is the permanence of it. In other words,
make it permanent.
if we do grant it based on the hardship, which we all seem to have some leanings toward, how do we deal with the permanence of it? I mean, that's,
I mean, the disability, granting it because of the disability.
I think Chris's
Yeah, that's
point
the
is
way
excellent,
that
Pete. You know, we ought to be trying to build handicapped accessible property.
So once it's
And
there, it's there.
because he has someone who's going to regularly use this house who is handicapped, we have the ability to give him variance without having to think about whether everybody who has a lot where somebody is built before zoning gets an automatic variance.
But what I'm with you there, but the question I have is the permanence of it.
Yeah.
In other words, when the person passes and is using it, does he have to remove it?
Well, he would only have to remove it if we made that a condition.
Exactly. And that's what I'm asking. Are we leaning toward that condition?
No, I'm not.
Okay. I'm not either, but,
I'm not.
all right.
Okay, before I officially continue the hearing, I'd also suggest that,
That sounds like the three of them are willing to go for the handicap, so we could just end it now.
We've already agreed that we're
Yeah,
going
we've
to continue,
All right,
Martha.
okay, all right. I heard three.
Yeah, because I'm really not comfortable with this totally. I'd like to hear what.
I think what Chris, my understanding from going to a couple of conferences is basically what Chris said. Peter, or whoever, I guess I can call OEP as well, is not going to be all that helpful in terms of how we make this decision.
Okay.
But we can ask.
No, I accept that.
We've already decided.
Do you
to
accept
ask.
that, dude?
Yes.
No, we can. We've already
Okay,
decided.
I was going to ask, let's make sure everybody goes up and looks at the property. While we
Look again.
look again. In the context of what we've been talking about, I will make effort to contact Peter.
Now, excuse me, just if we allow, well, maybe you can ask Peter if you don't know. If we allow that variance, can we condition it on it becoming a ramp?
Yes.
I think the quick answer is we can add just about any condition we want on any variance we grant
Okay.
that we think makes sense and is in the spirit of the zoning ordinance and whatever. I mean, we could say it has to be, I'm an extreme here, but we could say it has to be painted blue, I suppose, or orange so it's visible. Okay. If I get a conference call with Peter, I'll try to include everybody, or
Sure. Yeah.
because I think I find it helpful to have other people asking questions
Yeah.
about things that I don't think of.
Yeah, it's always-
Okay, it's 8:30 already. My gosh, I will now then continue the public hearing one more time to our next meeting on April 15th, 7 o'clock here at town offices. And with that, the hearing was continued. Any other business for our meeting? We will see each other all on April 15th.
Taxes all submitted?
Yes. Thank you for putting up with this.
I feel better.